When you are charged with a crime, you are presumed innocent under the United States Constitution, and the burden lies with the government to prove beyond a reasonable doubt that you are indeed should be convicted and you are guilty of the crime charged. When it comes to our Second Amendment rights, guess what? That methodology applies equally. Specifically, that when the Second Amendment is implicated by a modern-day gun control law, guess what? The burden shifts to the government, and the government has to do what? Overcome that burden with showing particular types of history. And when there's doubt, guess who wins? That's right. We're going to talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun and a constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans, and Israelis, by the way, about the right to bear arms. Check it out, not just in print, but also in Kindle, and of course on audiobook as well. All right, folks, so the United States of America case, USA versus Rahimi, is coming up in a couple days. We're going to be doing a lot of historical analogs and a historical discussion about that. History is going to come up hugely during oral argument in a few days, and I'm going to be covering it. I will do an entire hour-long telephone conference for all the members of the Federalist Society, including, I'm sure, a bunch of judges will tune in, as well as law clerks and lawyers and many people all across the country to see what I have to say about the results of that oral argument in the Rahimi case. But don't worry, I'm going to do an independent video just for you all. Of course, you're going to be welcome to join to the Federalist Society conference call. I will send that information out. But if you missed that, you can certainly join me here at the Four Boxes Diner after that major oral argument. And a big part of that oral argument is going to basically be history. In fact, almost all of the argument, I suspect, will involve basically history, historical analogs, and what is an appropriate historical analog to determine whether or not 18 U.S.C. 922 G8 is constitutional. As you know, 922 G8 deals with domestic violence restraining orders, which is a civil order in a civil case as opposed to a criminal case. Now, the reason why I want to talk about this one critical point today about history is this. This is one of these critical things. I'm going to give you language that you need to write down and take notes on for anyone that's talking about the Second Amendment in any kind of super geeky way, whether you're in meetings, whether you're a lawyer, whether you're a judge, whether you're whatever it is. I want to give you a very helpful and important bit of language from the NYSRPA versus Bruen case. This is something you always want to have in your back pocket, because this language I'm going to give you not from the Four Boxes Diner, it's actually from the Supreme Court itself, is going to be something that you can use to great effect whenever you're in a debate about history, which is critically important to the Second Amendment rights. Because as you know, the way we've talked about this, the interpretive methodology both in Heller and Bruen was you look at the text of the Second Amendment as defined by the Supreme Court. If a modern-day gun control law is implicated by that text, if it's implicated by that text in some respect, or the plaintiff or the Second Amendment person wants to engage in something that deals with the right to keep and bear arms, or has been accused of doing something with respect to the right to keep and bear arms and now has committed a crime under a modern-day gun control law, if that occurs, as you know, the Second Amendment is triggered, and once that Second Amendment is triggered, the burden shifts to the government to show that the modern-day gun control law is constitutional under the Second Amendment. And the only way to do that is to show that at the time of our founding in the 18th century, when the Second Amendment was adopted, in the year of our Lord 1791, that there were distinctly similar or relevantly similar analog laws on the books and enforced at the time. Airy-fairy laws, airy-fairy notions of law or justice or history don't count. There has to be specific laws on the books that are analogous to the modern-day gun control law, both the how and the why, meaning that the reason why those gun control laws or those laws on the books at the time were the same why, meaning, let's say, to stop street crime, is the same why that we see in the modern-day gun control law they're trying to uphold today. The why and the how of those modern-day laws has to line up with the how and the why of the historical laws in the 18th century. We'll talk more about that later. But the one thing I want to say is this. The burden is on the government. Just like in a criminal case, if you're charged with a crime, the burden is on the government. You don't have to do anything once you're charged with a crime. You can sit there and look out the window and do literally nothing. The entire burden of proof is on the government to show beyond a reasonable doubt that you committed the crime. So too in the context of Second Amendment cases. Once that text of the Second Amendment is implicated by the conduct of the Second Amendment person or the text of the modern day gun control law, then the burden shifts to the government. The burden shifts to the government to show that historical analog laws, which we've talked about before. Now, here's the key. If there is any doubt, if there is doubt or ambiguity about whether or not that 18th century historical law is an analog to the modern day gun control law, if there's any ambiguity about the history, this is very important to understand. If there's any question about the history at the time of the founding, if there's any ambiguity about what it means, if there's any incomplete records, if the anti-gun historians can't find the proof, if they can't find the statute, if they say the records have been lost in a snowstorm, if they say the records have been lost in a tidal wave, or were lost on a ship crossing the ocean or rounding Cape Horn, any of those excuses, guess what happens? The Second Amendment wins. The unqualified command, this is the Supreme Court's language, the unqualified command of the Second Amendment, i.e. shall not be infringed, is to be honored and respected and enforced in a court of law. Here is what the Supreme Court said in Bruen. And this is what you want to take a note of, folks, for those people out there really getting geeky, really arguing this, really needing to know this because you're going to court or elsewhere. Footnote number 11 in NYSRPA versus Bruen. This is what they say. They're talking about the Sir John Knight's case. Was it a case involving the Statute of Northampton, a law from England that was adopted long before the birth of William Shakespeare? Again, you don't need to know a lot about the Statute of Northampton, but the Statute of Northampton was a very big deal in whether or not you had a right to carry guns under the Second Amendment in NYSRPA versus Bruen, because the Statute of Northampton, again, which was adopted hundreds of years before the birth of William Shakespeare in England, dealt with allegedly certain restrictions on whether or not to carry. Ultimately, the Supreme Court said that statute simply meant that you couldn't go out in public with guns to the terror of the people, meaning you could not engage in riots and things like that. It wasn't like an absolute prohibition on carriage. Nevertheless, here's what the Supreme Court said about that, because there was a historical debate. There was a historical debate going back and forth about the meaning of a case called Sir John's Knight. Sir John Knight's case was a key case back in the day interpreting the Statute of Northampton hundreds and hundreds of years ago. And here is exactly what the Supreme Court said. And this proves the point that if there's any doubt or ambiguity, there's multiple plausible reasons about what a historical law means. The ambiguity weighs in favor of Second Amendment's unqualified command shall not be infringed. In other words, we win if there's historical ambiguity. Here's what the court says in footnote 11, quote, The dissent discounts Sir John Knight's case because it only arguably supports the view that an evil intent requirement attached to the Statute of Northampton by the late 1600s and early 1700s. But again, this is the Supreme Court, but again, the Second Amendment's bare text covers petitioners' public carry. The respondents, which is the government here shoulder the burden of demonstrating that New York's proper cause requirement is consistent with the Second Amendment's text and historical scope. Here's the key language. Ready? Listen carefully. This is the Supreme Court. Big deal. The court goes on and says the following, quote, To the extent there are multiple plausible interpretations of the Sir John Knight's case, we, the Supreme Court, we will favor the one that is more consistent with the Second Amendment's command. Period. Close quote. Did you hear what the Supreme Court just said there? When there are multiple plausible interpretations of a historical law in the context of a fight over the meaning of the Second Amendment, if there's ambiguity, and ambiguity in the law is defined as more than one reasonable interpretation of a clause, of a statute, of a contractual term, whatever. If you have ambiguity or multiple plausible interpretations of that historical law from the time of our founding, then the Supreme Court directs judges, inferior court judges, to, quote, favor the interpretation that is more consistent with the Second Amendment's command. And what exactly is that command in the Second Amendment? Well, we know it well. It is that the right of the people to keep and bear arms shall not be infringed. That is the law of the land. That is the unqualified command. And when there's ambiguity about the history, the government loses. Just like in baseball, the old saying, a tie goes to the runner. Here, a tie in history goes to freedom and to the Second Amendment's unqualified command, shall not be infringed. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed to me here, please do so. Don't feel free to like this video and share it with your friends. Follow me on X at Four Boxes Diner, and we will see you again very soon here at the Four Boxes Diner.
Orders up. Table 2A.